The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The first case is State versus Schalow, and we will hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Joe Hyde. I represent the state in this matter. This case is before the court on the basis of this court's grant of the state's petition for discretionary review to review the unanimous opinion of the Court of Appeals, which held that defendant was entitled to a pretrial dismissal of these charges on the basis of prosecutorial vindictiveness and a joinder violation. Just in terms of let me back up. I'd like to reserve 5 minutes of my time for rebuttal, if I may. Just in terms of the procedural history, it is worth noting that this case is in a pretrial posture. The Court of Appeals granted defendant's petition for writ of certiorari to review the denial of his pretrial motion to dismiss. The justification for doing that was the threat of a double jeopardy violation. Defendant in his motion to dismiss had alleged double jeopardy, the vindictive prosecution, and potential joinder violation. And the Court of Appeals granted review of that interlocutory order in order to address the double jeopardy violation. But then in the opinion, it sidestepped the double jeopardy issue altogether. A district attorney has a constitutional obligation to enforce the criminal laws of this state. In this case, the intent of the prosecutor was clear, and his public statements that were attached to the defendant's motion to dismiss, he was not unclear about what his intent was. He noted that domestic violence is unacceptable in the community, that the facts of this case show extreme brutality, and the district attorney indicated his intent to do everything possible to see that the defendant is held accountable for his actions. In other words, held accountable for his criminal conduct. Prosecutor has a state constitutional obligation to ensure that the criminal laws are enforced. The Court of Appeals found, however, a more nefarious purpose. The Court of Appeals found that this prosecutor was motivated not so much by a desire to enforce the criminal law, but by prosecutorial vindictiveness and by a desire to circumvent the requirements of the joinder statute, chapter 15-926. There is no evidence in the record to support the Court of Appeals finding that the prosecutor was motivated by vindictiveness or an intent to circumvent the statute. The evidence in the record demonstrates, these are the prosecutor's statements to the media, the evidence in the record demonstrates that the prosecutor's intent was to hold defendant accountable for his criminal conduct. The Court of Appeals in Schalow 1 made it impossible for the defendant to be held accountable for the attempted murder of his wife. The district attorney has a constitutional obligation to enforce the criminal law, and the prosecutor's expressed intent here is to hold defendant accountable for his criminal conduct. There are three issues in this case. There's the double jeopardy problem, the argument there that the initial indictment, which charged defendant with attempted murder and failed to allege malice, was in fact insufficient to charge him with anything. That was the subject of the prior appeal to this court in Schalow 1. I'm not going to dwell very much on that issue. The second issue is whether the Court of Appeals erred in finding a presumption of vindictive prosecution applied here. And the third, whether the Court of Appeals erred in finding a joinder violation, specifically whether the Warren exception to the Furr rule was satisfied in this case, although defendant hadn't even alleged that Warren exception in his motion to dismiss.
Haven't identified the issues as you now have, and going back to the comments of the prosecutor, are you contending that the prosecutor's comments are irrelevant to our analysis of the resolution of these three issues?
Not at all, Justice Morgan. I think the prosecutor's comments are the best evidence that we have of what his actual intent was. The problem here is that the Court of Appeals, although they seem to recognize that these were properly in the record, the Court of Appeals then turned around and rejected the intent to enforce the criminal law of the state as a legitimate motive of the prosecutor. The best evidence we have of the prosecutor's intent here is what he said. He said he was interested in enforcing the criminal law. The Court of Appeals made it impossible to hold defendant accountable on the basis of a conviction for attempted murder. And so when the prosecutor came back with these additional charges of felony assault and child abuse, his intent was plain. I mean, he said it several times. The goal was to hold defendant accountable for his criminal conduct. The district attorney was not interested in circumventing the joinder statute. He wasn't trying to penalize defendant for exercising his right to appeal. He was trying to salvage something of this criminal prosecution. He was trying to hold this defendant accountable for nearly killing his wife.
Is there any contextual relevance in light of the legal issues that we are to resolve? I understand what you're saying about the prosecutor's position as an elected official, but in terms of our role as legal analysts, is there any contextual difference from what you're saying as compared to what our charge is as the court?
A little bit, Your Honor. If I understand your question correctly, I don't think it's absolutely necessary to reach this particular evidence, because the Court of Appeals actually found that a presumption of vindictiveness was appropriate here. The reason these statements are relevant is that the United States Supreme Court has said again and again that that presumption of vindictiveness may be overcome by objective evidence of a legitimate motive. And what those statements show is that there was objective evidence of a legitimate motive here. I'm not sure if that really gets at your question. There is sort of a technical analysis to be done of how that presumption works, of how it plays out in this case. And those statements come in only sort of at the bottom of that consideration, because the United States Supreme Court has said that that presumption of vindictiveness may be overcome when you have objective evidence of a legitimate motive. And what you have in this case is objective evidence of a legitimate motive. The reason I start with that is that both of these two claims, the vindictive prosecution and the joinder violation, really center on what was the district attorney's intent. What was the motive of the prosecutor? Was it something nefarious, like the intent to circumvent the joinder statute, like an intent to penalize the defendant for exercising his right to appeal? Or was there a more proper, a more legitimate motive for bringing these additional charges? And what we have here in the record is objective evidence that there was a legitimate motive.
Just to follow up on that, I didn't understand the Court of Appeals opinion to be making a finding about the subjective intent of the prosecutor, but rather making the point that merely saying that this prosecution is being brought to enforce the law and to punish a wrongdoer is not sufficient to overcome the presumption, because that is true of every prosecution. And so this wasn't particular to this prosecutor, but rather raising the question under the constitutional standard, what overcomes the presumption of vindictiveness. And I also, along the same lines, would ask you whether the vindictiveness here is necessarily a subjective type of vindictiveness, because the cases talk about the impact not only on this defendant, but on the system generally, if someone will not exercise their rights to appeal if they are at risk of greater charges if they win their appeal.
Right. Your Honor, you're precisely correct that the Court of Appeals really found it was the presumption of vindictiveness and not so much actual vindictiveness in this case. But there was sort of a hint, a dig, if you will, at this particular prosecutor when the Court of Appeals said, and this is on page 376, the prosecutor had a personal stake in the outcome. The Court of Appeals said that based on no evidence whatsoever, except for the fact that the same prosecutor's name was on all of these indictments. So I think Your Honor is correct. There need not be any examination of subjective intent, particularly when we're dealing with whether a presumption is appropriate. But there was a finding here. There was at least a suggestion that the Court of Appeals found that this prosecutor was motivated by a personal stake in the outcome. There is no evidence in the record supporting that. The fact that the same district attorney signed all of the indictments evidences his fulfilling his constitutional obligation, not that he has a personal stake in the outcome of this case. But to back up, Your Honor is precisely correct that it's really more of an institutional concern with regard to the presumption of vindictiveness. The way the United States Supreme Court has described that it works, this is in Goodwin, a presumption of vindictiveness is warranted when the possibility of increased punishment poses a realistic likelihood of vindictiveness. And as Your Honor pointed out, it has to be a realistic likelihood, not just particular to this case, but sort of categorically, every case of this type. The problem here is that the Court of Appeals, I don't think, really understood how that presumption is supposed to work on several bases. First of all, in the rule statement, they said, this is on page 375, Blackledge and Wagner stand for the proposition that where a defendant is indicted on charges carrying a significantly increased potential period of incarceration after the defendant does what the law permits him to do, that is appealing, a reviewing court may apply a presumption of vindictiveness. That's inaccurate. The way that it's articulated there is really more of a post hoc ergo propter hoc. That is, it happened after, therefore it was because of. If the charges are brought after the defendant appealed, well, that must have been because he appealed. That's neither true in logic nor in law. The particular problem there is it would obviate the possibility of a prosecution where the defendant succeeded in having a conviction overturned on the basis of a defective indictment. In that case, the state is permitted to bring additional charges. He can go back and be retried. So the suggestion that a presumption of vindictiveness is warranted every time new charges are brought after an appeal, that's not how the rule works at all. The way the presumption of vindictiveness works is more properly explained by Blackledge itself. What happened in Blackledge was, incidentally, it's a North Carolina case, the defendant appealed from district court to superior court, and upon the defendant's request for a new trial, de novo in superior court, the prosecutor then came in with more serious felony charges. And what the United States Supreme Court said was a presumption of vindictiveness is warranted when the state brings new charges as a result of the defendant's exercising his right to appeal for trial de novo. That's the situation where those other charges could chill the exercise of a defendant's right to appeal. Not the situation here, where the Court of Appeals in Schalow 1 basically said this defendant could not be prosecuted for the crime that he very clearly committed, that is, attempted murder of his wife. Goodwin in footnote 8, I think, recognizes that it's not, sorry, let me get the, the presumption could be overcome by objective evidence justifying the prosecutor's action. The court noted this would clearly be a different case if the state had shown it was impossible to proceed on the more serious charges at the outset. In this case, the Court of Appeals, due to its erroneous interpretation of that indictment, made it impossible to proceed against the defendant on the crime he did commit, attempted murder. So these other charges that the prosecutor brought, we're not penalizing the defendant for appealing. We're not trying to chill the exercise of the constitutional right. The district attorney is attempting to exercise his constitutional obligation to enforce the criminal law of the state. That's what he said. To hold this defendant accountable in some way for the domestic violence, for the tremendously cruel assault he made on his wife.
Mr. Hyde, help me just a moment. Is this to be determined as a matter of law? should we consider a remand to the trial court, let the trial court weigh the presumption on the one hand versus the evidence on the other hand? Is it, you seem to have indicated it's an objective test as opposed to subjective test. What's the best, what do the cases instruct that we should do?
I don't think a remand to the trial court is necessary here, Your Honor. What the trial court did in a pretrial posture is deny the motion to dismiss, the pretrial motion to dismiss. The hint or suggestion or possibility of vindictive prosecution is something that can be vindicated upon an appeal from a final judgment. So first of all, remand to the trial court, I don't think would be appropriate. It might be necessary to remand to the Court of Appeals to have the Court of Appeals apply the rule correctly. Because I think the Court of Appeals analysis of that presumption of vindictiveness is obviously wrong. What the Court of Appeals said was, because this defendant faces the possibility of increased punishment, then a presumption of vindictiveness is warranted. I already pointed out how their rule statement is inaccurate, but going further, the Court of Appeals overlooked the significance of Section 15A-1335. Significantly, this was not the argument that the defendant made to the Court of Appeals, because the possibility of increased punishment based on this conduct is simply not a viable possibility here. 15A-1335 says, when a conviction or sentence imposed in Superior Court has been set aside, the court may not impose a new sentence for the same offense or a different offense based on the same conduct. Now, defendant in his brief is going to say the state has conceded a point that it hasn't conceded before. That's not a concession. That's the plain language of the statute. There's no way that this defendant could receive a greater sentence than he got for the overturned conviction for attempted murder. And yet that possibility is what the Court of Appeals relied on in finding that a presumption of vindictiveness was warranted.
Well, Mr. Hyde, let me make sure I'm following your argument here a little bit. Are you or are you not saying that, assuming we were to allow this case to proceed as you have asked us to do, a sentence in excess of that which was originally imposed upon the defendant based on the attempted murder conviction could be imposed?
Would be what? I'm sorry?
You said could. I mean, I guess in essence, bluntly, are you conceding that if the state was allowed to proceed on remand as you have requested,
it wouldn't be sentenced higher than he was before? Yes.
So that is the most that he could get is what he was received at the time of the first trial. The state is conceding that.
Well, first trial, his trial for, he was actually convicted of attempted murder and got something like 200 months. Yes, that under the statute, that creates a ceiling for the sentence that the defendant can receive. Yes.
And the state is conceding that that bar exists in this case, assuming that the defendant was to be retried on the charges that you're seeking to have reinstated.
I'm not sure there's any way around that. Yeah, the state is conceding that because that's what 15A-1335 said. Yes, Your Honor.
And to follow up on a question that the Chief Justice asked you, I mean, if you look at the trial court order in this case, it's essentially a one-page, fairly
pretty summary,
pretty bare bones order. I'm understanding you to say that the proper analysis to undertake with respect to vindictive prosecution here is first determine whether a presumption of vindictiveness exists, and regardless of whether that presumption exists, the defendant has the right to show actual vindictiveness, and you have the right to show
legitimate
motivation. Why does that not almost inherently require findings of fact?
The reason that does not require findings of fact is that the trial court denied the pretrial motion to dismiss, legitimately finding that the defendant produced no evidence of an illegitimate motive. There was no evidence of actual vindictiveness, and that a presumption of vindictiveness was not warranted. Now, trial court didn't spell that out specifically, but that I think is inherent in this summary denial of the motion to dismiss. The reason that the Court of Appeals has to be overturned is that the Court of Appeals expanded that presumption of vindictiveness to a scenario, to circumstances in which it is simply inapplicable, that it's never been expanded to before. So sure, there might be a necessity for the trial court to inquire further upon another motion to dismiss or a further presentation of actual vindictiveness here. But so far, what the defendant has produced is statements from the prosecutor that indicates nothing less than a legitimate motive. That alone, I mean, even assuming a presumption were warranted, we've got objective evidence of a legitimate motive here. There's no further findings or conclusions that need to be made. I would like to shift real quick to the third issue, which is the joinder violation. And as I pointed out before, defendant in his motion to dismiss made no argument that the bringing of additional charges was an intent, was with the purpose of circumventing the joinder statute. The reason that matters is that 15A-926, which is the joinder statute, says that it uses the term offenses when it really means indictments. Two or more offenses may be joined for one pleading for trial when the offenses are based on the same act or transaction. And then it says when a defendant has been charged with two or more offenses joinable under this section, his motion to join must be granted. And then defendant tried for one may thereafter move to dismiss a joinable offense made prior to trial, so forth and so on. What this court held in Furr was that where there had not been a prior indictment for the additional charge, there could not have been a joinder of those charges. Offenses in that statute means indictment. Offenses are joinable only when multiple indictments are returned at the same time. So under the plain language of the statute and under the rule in Furr, these charges were not joinable because the defendant at the time that he was tried for attempted murder had not been indicted for felony assault or the child abuse charges. Now, what the Court of Appeals did in Warren, it came back and it recognized as an exception to the rule in Furr that where the defendant has the burden here, where the defendant can show that the failure to obtain a new indictment was for the purpose of circumventing that joinder statute, then the defendant would be entitled to a dismissal on that basis. That nefarious purpose of trying to do an end run around this requirement that joinable offenses be joined, then the defendant would be entitled to a dismissal of those later charges. The defendant in his motion to dismiss here never alleged that that was the prosecutor's purpose. What he said was the charges should have been joined under the statute. Warren wasn't cited. The principle in Warren was not referred to. And yet he made that argument on appeal and the Court of Appeals bought it. The rationale that the Court of Appeals followed, it explained that it was going to find the Warren exception was satisfied because one, defendant has shown that both Warren circumstances are present. What it meant there was that Warren had said presentation could be made by a defendant that if the prosecutor knew about the additional evidence at the time of the first trial, and if the evidence at the second trial was going to be the same as the evidence at the first trial, one or both of those would support but not compel a finding that that exception applied. The Court of Appeals said, we conclude that defendants made a showing that should have compelled the determination. Warren said would not compel. So the Court of Appeals, I mean, it's flatly inconsistent with what Warren was trying to do. The second factor that the Court of Appeals cited, the state had multiple previous opportunities to join the offenses on which it now seeks to try the defendant. Under Jewell, offenses under the joinder statute means indictments. Those indictments for the additional offenses hadn't been returned until years later. As a matter of fact, the state has not had multiple previous opportunities to join the offenses. Warren did not overrule Furr. Furr still holds that joinable offenses means joinable indictments. These additional indictments were not returned until later. And then the third factor that the Court of Appeals cited, the state has neither argued that it was somehow unable to try the offenses, nor proffered any explanation for why the offenses were not tried earlier. The Court of Appeals keeps going back and forth. It wants to use these statements that the prosecutor made that he was trying to enforce his constitutional obligation, but then when they have to explain why the warrant exception applies, they say, prosecutor hasn't presented any explanation for why he's done that. The prosecutor's explanation was provided in his statement to the media. This is a legitimate purpose to enforce the criminal laws of this state. It was the prosecutor's desperate attempt to
Well,
hold
Mr. Hyde, I mean, this is something that I was going to ask Mr. Schatz too. I mean, you have repeatedly said that a desire to obtain the imposition of punishment for criminal conduct is a legitimate justification for proceeding. Mr. Schatz, if I understand his brief, has argued in effect, well, that, as Goodwin suggests, that argument implies that any prosecution which is motivated for the purpose of punishment is necessarily legitimate. Punishment's inherent in the system. That's what the system's set up to do. Therefore, if we accept that as a legitimate justification, then there's no such thing as vindictive prosecution. And those are my words and not his. I hope he'll correct me if I'm misstating his position. But assuming I've accurately portrayed his position, why is that position not legitimate in your view?
The presumption is that a prosecutor has a legitimate motive. That's stated in Goodwin, it's stated in Armstrong. You've got to begin with the assumption that the prosecutor has not been actuated by a nefarious purpose. What Goodwin meant when it said that every criminal action is for the purpose of imposing punishment, and therefore the intent to impose punishment doesn't provide a meaningful distinction between a legitimate purpose and an illegitimate one. What it was trying to say was, nothing else appearing, we have to assume that the prosecutor's motivation was good. What the Court of Appeals and defendant have done is flipped that on its head and said, look, you can't tell if the prosecutor is just trying to enforce the criminal law. It must have been up to something sneaky, right? The presumption is the prosecutor's motivation was legitimate. Goodwin, Armstrong, they recognize that an intent to prosecute the criminal law, an intent to enforce the criminal law is a legitimate motivation. That may not be a way to distinguish between a good motive and a bad one, but the defendant still has to come forward with some evidence that it was to penalize his exercise of his right to appeal. And there's no evidence of that here. All we have is evidence that the prosecutor intended to enforce the criminal law of this state. If that's to be discounted, if that's not to be considered, then we're left with a presumption that the prosecutor had a good faith intent, not that his intent was to penalize the exercise of a right to appeal.
You're well within rebuttal, but you
Thank you, Your Honor. The state would respectfully request that this court overturn the decision of the Court of Appeals.
Thank you, counsel. We'll hear from the appellee.
May it please the court. I'm Assistant Appellate Defender Dan Schatz, and I appear today on behalf of Mr. Schalow, the appellee in this court. The starting point for both the vindictive prosecution and the joinder arguments or issues is that the state is entitled to one full and fair opportunity to prosecute a defendant for his criminal conduct, but not more than that. And the United States Supreme Court has said, and they say it mostly in the context of double jeopardy, but it's an underlying principle that cuts across a number of doctrines. Quote, the underlying idea is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. And in Goodwin, the United States Supreme Court recognized that there is this underlying idea that there's one full and fair attempt to prosecute a defendant. It cuts across a number of legal doctrines, including law of the case, res judicata, collateral estoppel, double jeopardy, all of these principles. And I would add it also cuts across civil litigation as well, the idea that a dispute should be resolved between the litigants in one single case, one single course of action. And so turning specifically to the vindictive prosecution issue, the state argued that said that the Court of Appeals found a quote nefarious purpose. And I think it's important to understand that the term vindictive prosecution is a legal term of art. And it does not have the pejorative connotation that the word vindictive has in common parlance. And Blackledge and Goodwin tell us this, and Blackledge, excuse me, Blackledge tells us this because it says very clearly in holding that what happened in Blackledge was a vindictive prosecution, it said very clearly that there was no evidence that the prosecutor had bad faith or malice, that there was anything malicious about it, but yet it held that that was a vindictive prosecution. And Goodwin clearly explains that as a term of art, what a vindictive prosecution is an adverse charging decision that is made in response to the defendant's successful invocation of his rights. And so,
Mr. Schatz, let me make sure I'm following you up. I hate to interrupt people this early, but I want to make sure I'm not missing something. You're saying on the hand the vindictive prosecution is not a term of art, and now you're talking about motivation. And one of the things I've been trying to figure out is to what extent is the subjective motivation of the prosecutor A, relevant, and B, determinative under the analytical framework that you think we ought to adopt. Could you help me with that a bit?
Absolutely, Your Honor. And to be clear, I'm saying that vindictive prosecution is a term of art, and it is purely objective. And what it means is an adverse change in the charging decision because of the defendant's successful invocation of his rights, the successful overturning of the conviction.
And maybe my confusion is arising from your use of because almost to me sounds like the desire to punish the defendant for engaging in the protected activity is what's motivating what's going on. And I'm obviously misunderstanding you. Tell me what I'm misunderstanding.
I don't think that's exactly correct. I think it's just that it is a response. And so Goodwin, for instance, recognizes an exception, and this parallels an exception in the Joinder statute, where the prosecution was unable to bring the original charges at the time of the first prosecution. So in that situation, that would overcome the presumption that the change in charging decision was a response to the defendant's successful invocation of his rights. But the presumption in Goodwin, or Goodwin makes clear that the presumption, it's a question of timing. If the adverse change in the charging decision comes after the defendant's successful invocation of his rights, it's presumed that it's a response to that successful invocation, and that's what can be overcome by a showing that the new charges could not have been brought at the time of the prosecution. And so the example given in the United States Supreme Court case law is where there's an initial prosecution for an assault and the defendant successfully challenges that, but in the meanwhile the victim has now died and there's a homicide prosecution. And so that's the quintessential example of overcoming that presumption of vindictiveness.
What should be the impact of the fact that our indictment jurisprudence is very different from federal indictment jurisprudence? In other words, federal indictments are much more easily cured, whereas in our state, we have the belief that if the indictment is invalid, then the court did not have subject matter jurisdiction, so the case could not have proceeded at all. So here you have situations where it was determined by the trial court that the indictment was originally flawed. Then the case was prosecuted again, and only at that point did the Court of Appeals determine that there was, in fact, the indictment was not as basically flawed as the trial court and the district attorney and the defendant, I guess, originally believed. So, you know, you've got quite the technical procedural history. But again, at the core of this is our indictment jurisprudence and the understanding that, you know, if there were no jurisdiction, then nothing technically happened, versus the federal indictment jurisprudence. How would you react to that?
Well, Your Honor, I think that brings us back to what happened at that very first trial, and the fact that there is a distinction in our case law between an indictment that charges no criminal charge and an indictment that does charge a criminal charge. And as defense counsel repeatedly stated at that first hearing, at the first trial, there was case law on the books at that time in State v. Bullock that said an indictment that was worded the way that first indictment was worded did charge attempted voluntary manslaughter. So the scenario where there was never any jurisdiction in the trial court simply did not occur in this case. And it was, like I say, this wasn't the Court of Appeals in the first appeal, did not come up with a novel interpretation of the indictment requirements. It applied a case that had been on the books for some roughly 8 or 9 years before the state got that first indictment. And so what, you know, the state had in that first case, because there was an indictment, they had a chance to prosecute Mr. Schalow and hold him responsible, as the state would now say, for his criminal conduct. And really, what we would suggest is ever since then, the state has been trying to avoid the consequence of its own litigation mistake. And that's, you know, in almost 60 years ago in the Burkhead case, this court recognized that the fact that the state starts a trial and then realizes maybe it should have gotten a different indictment doesn't give the state a valid grounds to stop the proceedings and go get the indictment they wish they had gotten from the outset. So that's been well embedded in our jurisprudence long before this case started. And so, you know, that's really the situation we're dealing with here, where there was, based on the law in place at that time, unquestionably jurisdiction in the trial court. And defense counsel pointed that out at the first hearing and very plainly, and as the first appeal showed correctly, you know, told everyone what the consequences would be if a mistrial was declared and over its objection. And so, you know, that's what we're dealing with here. And that's why the difference between our indictment law and federal indictment law isn't a hurdle in this case.
Can I ask you? Oh,
I'm sorry. No, go ahead.
what your response is to the state's argument that essentially we no longer can have vindictive prosecution in North Carolina because we have a statute that says that 15A 1335 prevents a higher sentence from being imposed. So the kind of presumption that the federal case law constitutional precedents say exists can't happen in North Carolina.
Two things, Your Honor. First, I would call the court's attention to footnote 8 in the Blackledge case, where the court is expressing its disagreement with the dissenting opinion in that case, and says flat out, this is in the second paragraph of footnote 8 of that opinion, that our holding today is not that the defendant was denied due process by the length of the sentence imposed, but rather by the very institution of the felony indictment against us. So it is the new charging decision that is the due process violation. That's the first point. And then the second point with respect to 15A 1335, as it applies to this case at least, is that it doesn't fully protect Mr. Schalow for two reasons. First, because the sentence that was imposed at the second trial itself was already substantially in excess of the maximum sentence that could have been imposed properly at the first trial, as the Court of Appeals recognized. And then the second thing is that there is an important distinction in the procedural posture between this case and between what happened in Blackledge and North Carolina v. Pierce. And this comes from Goodwin at page 376 of 457 U.S. reports, when it's talking about the Pierce and the Blackledge case. And it says both Pierce and Blackledge involved the defendant's exercise of a procedural right that caused a complete retrial after he had been once tried and convicted. So in those cases, the defendant was still, even after his successful appeal, subject to a retrial for the original charges. And in this case, because the outcome of the first appeal was a dismissal rather than a retrial, Mr. Schalow was not subject to a prosecution at the time of the new charging decision. And so that's an important distinction when looking at the protection that's afforded here in terms of what the impact of that adverse change in the charging decision is that, and we would suggest that you should look at what a person was facing before the adverse charging decision and now what the person is now facing. And so we would suggest that 15A1335 does not resolve that or put in a protection that wholly replaces the protection of the vindictive prosecution doctrine.
Does it have any bearing on how we ought to look at the questions involving vindictive prosecution and non-joint?
I'm not sure I understand your question, Your Honor.
All right. Well, I've had some discussion with both you and Mr. Hyde about the analytical framework that we ought to use in trying to evaluate primarily the vindictive prosecution claim. Does the state's concession that 15A1335 precludes the imposition of a greater sentence, should that affect how we look at the vindictive prosecution decision at all?
Not in this case, Your Honor. And again, that's because that statute only focuses on the judgment that was imposed at the second trial in this case. I mean, this case is unique procedurally in that, we're essentially looking at the third go around here, not merely the second. And that makes an important distinction here, because really what we should be looking at is what was going on at that very first prosecution under the first indictment in 14 CRS 50887. And that's why I don't think 15A1335 really bears on the issue in this case. There might be other cases where that might have a different impact.
Thank you.
Counsel, if I could, and I apologize, Chief Justice brought up just a few moments ago our indictment jurisprudence, and so I've got a question that's related to that. And if I take you over into the joinder argument before you want to, I apologize. But in reading your brief, you seem to propose a rule that would require a prosecutor to charge every potential charge at the beginning of a case. And you opened your argument with the state only gets one full and fair opportunity to prosecute a defendant for a criminal offense. Are you proposing a rule that would require a prosecutor to indict or charge all potential offenses at the beginning of the case?
Your Honor, I am proposing, not when you say the beginning of the case, certainly what we think both, and this hits both vindictive prosecution and joinder, as Your Honor recognized, is that by the time the state is ready to call a case for trial, the case is supposed to be fully investigated. And so in Goodwin, the United States Supreme Court said, and this is from page 381 of Goodwin, and I quoted in the brief, that once a trial begins, and certainly by the time a conviction has been obtained, it is much more likely that the state has discovered and assessed all the information against an accused and has made a determination on the basis of that information of the extent to which he should be prosecuted. So I think the United States Supreme Court would endorse the proposition, or has endorsed that proposition, that by the time the state calls a case for trial, it should have made a determination of the extent of prosecution. And I think the official commentary to 15A926 shows that statute was intended to enforce the same idea. It says that the cases or charges must be tried together absent some reason for a separate trial. That's the last word, the last phrase in the official commentary to the statute. And so the idea here is that, yes, once the state has made a full investigation of the circumstances, it should make a deliberate decision of how to prosecute. And I would point out, and I noted this in the brief, in his closing argument in the first trial, the prosecutor said that that's exactly what had happened. He had elicited testimony from the investigator that prior to landing on the idea of charging Mr. Schalow with attempted murder, the investigator had consulted with the district attorney, and Mr. Newman told the jury in his closing argument was that a lot of thought and information had gone into that charging decision. So the state did, in fact, make a conscious decision. And again, I think it's significant in this case that originally that multiple assault charges that are parallel to the ones now indicted had been taken out by warrant before the state chose to get the indictment that it wanted to charge Mr. Schalow with attempted murder. And so, yes, that was a conscious charging decision. And yes, I think both the statute, the Joinder statute, and the constitutional vindictive prosecution idea is that, yes, the state should, in fact, bring out the charges unless there's some specific reason why that could not have been done. And so, again, when an investigation leads to new evidence, so very specifically in the Warren case, this court goes on for several pages explaining the evidence at the hearing in that case, where the prosecutor explained exactly why he did not have sufficient evidence to bring the new charges at the time of the first prosecution, that in fact those new charges depended on, first of all, the location of the victim's pocketbook after the first trial had been concluded, and second, on the defendant's trial testimony about what had happened that he gave at the first trial. So that's why in Warren the trial court actually found that the new charges could not have been brought at the time of the first trial. And so that's, I think, important to understanding it is, yes, that unless there was some actual impediment, unless the state's initial investigation doesn't reveal all the evidence or something along those lines, or there's some change in the factual circumstances, that yes, the state is expected to make a decision on the extent of the prosecution. And now that we're into the Joinder issue, a couple of things I want to bring out. The state says that it's necessary to plead the Warren exception, as if that's a different source of relief than the statute. And Warren itself, in the text, says that if the defendant makes the showing that the case describes, the defendant is entitled under NCGS 15A926C2 to a dismissal of the additional charges. And that's the end of the quote. And that's at page 260 of this court's opinion in Warren. So the idea is that when that exception applies, the defendant is entitled to relief under the statute. Now, in his motion and in the argument in the trial court, the defense repeatedly, the state made this deliberate choice to proceed on the attempted homicide indictment and not on the assault charges and not on any other charge. And that is the essence of the requirement under the joinder statute. And I want to highlight the fact, and we talked about this in the brief, that the text of the statute does not say, it does not say indictments may be joined in one pleading. It does not say indictments may be joined for trial. It says offenses. And offenses is a term with a well-recognized meaning. It means criminal charges that can be brought as a result of the defendant's conduct. And I want to point something out that's kind of subtle and maybe a little bit down in the weeds, and I didn't notice it until this weekend when I was preparing for this argument. But in Furr, when the court gets to the defendant's joinder argument, it drops a footnote and quotes the statute. And this is on page 724 of 292 NC reports. And the version of the statute that is quoted in Furr is missing three important words. As it appears in the book, it says under joinder of offenses, it says two or more offenses may be joined in one pleading when the offenses, and then it has ellipses, are based on the same transaction. And the three words that are missing after the words in one, or after the phrase in one pleading, are or for trial. And when I noticed that, I looked at the legislative history, and this statute has only been amended once, and that was in 1975. And I pulled up that session law, and it's a technical corrections bill that was enacted before Chapter 15A ever went into effect. And it adds those words or for trial after the phrase in one pleading. And I think what that's sort of an indication that perhaps the Supreme Court was not looking at the operative version of the statute when it reached the outcome it did infer. Because the idea that multiple charges can be joined for trial without being joined in a single pleading is important. And it recognizes, again, it brings back to what this court recognized in Burkhead in 1962, that the state has control of the indictment process. It has substantial control of the criminal calendar. And again, this also gets back to Justice Berger, to your question. The state has control and can get the case set the way it believes it should be before calling it for trial. And that's directly what the Court of Appeal, this court recognized in Burkhead. And the joinder statute should be understood in that light, is that the state, yes, should get everything ready when it calls a case for trial and prosecute the defendant the way the state believes the defendant should be prosecuted to bring about the result the state believes would be appropriate. And this, having made that decision, the state should not be allowed to, if it does not like the outcome of the prosecution it chose to bring, you can't redo it and start over and take a second shot. The principle here is the state doesn't get to keep a backup plan in its back pocket here. The state is supposed to bring it up, try the defendant, and abide by the results. We think both the vindictive prosecution principle and the statutory joinder principle are based on the same notion of one full and fair opportunity to prosecute a defendant. I think the opinion below from the Court of Appeals properly applied those principles. And unless there are any further questions.
I did have one, Mr. Schatz, in this was really an attempt to, asking a whole bunch of analytical framework kind of questions today, and here's one last one. If you look at Warren, it seems to me the operative paragraph in which it talks about how to apply the tests that it enunciates. It says, in essence, if the defendant shows, for example, that the prosecutor was aware of substantial evidence the defendant had committed the crimes, there'd be some evidence of delay was for the purpose of circumventing the statute, as showing that the state's evidence, the second trial would be the same as the state's evidence in the first, would also tend in that direction. Then the last sentence in that paragraph said, a finding of either or both circumstances would support but not compel a determination by the trial court that the prosecutor withheld the additional indictment in order to circumvent the statute. I assume you're a lot more familiar with that language than I am, but that sounds to me like ultimately we're talking about a question of fact here. Are we?
I would agree that we are, Your Honor, but the point I would make about that is this. So first of all, I think the record conclusively shows those things. I mean, the prosecutor at the hearing on the motion to dismiss, and particularly when they move on to start talking about the discovery, repeatedly states that the evidence is going to be the exact same, with the exception of this one doctor who has not actually conducted any examination in connection with the case. And we know, you know, from the fact, and he also says there's been no further investigation. So the evidence sort of conclusively establishes both of those things. And
I
then
guess
the other
that's
thing,
I guess that's my question. I mean, assuming for purposes of discussion that the evidence, to use your words, conclusively establishes those two things, does that end the inquiry?
we would think that it does, Your Honor. And again, unless because the exceptions.
If that's the case, then we've got the sentence says finding of either or both of those circumstances would support but not compel such a determination. And that's what I'm trying to understand is how your argument fits with that thing.
Your Honor, to do that, I think you have to go back to the actual language of the statute and the exceptions that are built into it. And particularly the one is I believe it's 926C3. And it is that the court finds that either there wasn't sufficient evidence at the time of the first trial, or because of some other reason, the ends of justice would be defeated if the motion were granted. So I suppose there's some wiggle room in there, but again, once you have the understanding that from Goodwin, that simply a desire to hold the defendant accountable is not a sufficient reason to because that would be something that would swallow up the entire statute. The state has not proffered anything in this case that would suitably, trigger that exception. So what I guess we're saying is we think the record is uncontested that the state could have brought these charges at the time of the initial prosecution, and that there was no sufficient reason shown by the record for the state to do so. But I would add, and this gets back to Justice Newby's question to Mr. Hyde, if the court disagrees, then I do think that at a minimum, a remand for findings of fact and conclusions of law in the trial court would be required. And so if that answers your question, having said that, we would ask the Court of Appeal, this court, to affirm the Court of Appeals. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. Very briefly, defendant has asked this court to take judicial notice of a removal proceeding against the district attorney. And paragraph 13 of that order that the defendant has asked this court to note says the allegations concerning the Schalow case could, if true, constitute willful misconduct in office or conduct prejudicial to the administration of justice. I wonder if defendant is willing to explain to the trial court that vindictive prosecution is merely a term of art. It's not indicative of a nefarious purpose. The whole point here is that vindictive prosecution is indicative that the prosecutor has done something illegal, if not also unethical. That's the whole reason, as I understand it, why defendant has asked this court to take judicial notice of that removal proceeding. It is a term of art. It is a legal concept that an appellate court has to analyze properly. And I think it's significant that entirely lacking from my colleague's argument was any suggestion that the Court of Appeals properly analyzed vindictive prosecution here. In fact, defendant pointed this court to the footnote in Blackledge v. Perry. Our holding today is not that Perry was denied due process by the length of the sentence, but rather the very institution of the felony indictment against him. The Court of Appeals held that a presumption of vindictiveness was warranted because of the length of the sentence. If my colleague is right, then the Court of Appeals has to be overturned. This woman was in the hospital for 3 weeks. Defendant beat her so bad, she was in the hospital for 3 weeks. We deal here with a technicality. I don't blame defendant for wanting to avoid the consequences of his criminal conduct on behalf of the technicality, but there's no denying the fact that that's what's happening. District attorney has made his intent plain. He wants this defendant to be held accountable for his criminal conduct. She was in the hospital for 3 weeks.
Thank you, counsel. I believe your time has expired. Thank you to counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is in recess. God save the state and this honorable court. Thanks, counsel.